This case is GW versus the Florida Department of Children and Families.
Hey, please, court. Good morning, Your Honor. Richard Joyce on behalf of the father, GW, who has petitioned this court for writ of certiorari to quash the shelter order that was entered on April 11th by the Honorable Cindy S. Lederman.
Mr. Joyce, it seems to me that AG versus DCS from the 1st District on July 26, 2011 is dispositive of the issue.
I would say so, too, Your Honor. I mean, it's essentially the same fact. What happened in the trial court below is that Judge Lederman appointed counsel, myself as trial counsel.
But you weren't there.
But I wasn't there, more than halfway through. And that's the problem with these cases. Thank God the regional counsel is now there because there is actually representation for one parent. But in this case, there was no representation for
all this occurred over a 24-hour period. The petition was filed on the 10th, and then the 11th, I think, and then the hearing was the next day.
The hearing was on the 11th. The removal was on the 10th. Late in the evening was the removal of the little girl MW down in Key Largo. The little boy, RKW, was born on the 8th in Homestead Hospital, and that's why the case ended up in Miami, because the child was born in Homestead, even though MW lived her whole life down in Key Largo.
When did these proceedings start?
The proceedings started?
This proceeding, yes. This
proceeding started on the removal on April 10th by DCF, and the first hearing was on April 11th before Judge Lederman.
At 7:45 a.m.
No, that was at 1:30 in the afternoon. The removal was in the night before.
What I'm trying to get to is how long from the time the proceedings started until the hearing was there to get a lawyer? Probably
less than 24. But, that goes back to there's no indication that the father was advised of his right to counsel, or that he had counsel.
Well, I read the transcript, and when you read AG from the 1st District, I mean, it's clear that the father was not advised, look, you have a right to have a lawyer present here with you for this hearing. And AG tells us that he doesn't have an affirmative duty to say, wait a minute, Judge, I want a lawyer, in the absence of him being advised that he's entitled to a lawyer. Is that correct?
That's correct, Your Honor.
The statute says the same thing. Is that correct?
The statute says the same thing. And the problem...
So he had been advised by the court that he has a right to have a lawyer present at the hearing. Then what is being appointed, but the lawyer's not here with him right now. He says, well, that's okay, Judge. I want to proceed with the hearing. That would have been a different story, right?
Correct, Your Honor. But he said later on in the transcript, he said, I didn't even know I had a lawyer. Who's my lawyer?
In fact, he asked to speak a couple of times.
Yes.
And at the very end, eventually, the court said, what was it that you want to say, Mr.
GW, yes, Father.
GW, right.
Now, the other thing is that is disconcerting about DCS argument is they try to shift the burden to advise the father that he has a right to counsel from the court, which it has an affirmative duty under the rule 8.320 to advise and make sure that the father understands it to the father.
Right.
And in this court, in AG, in Ray AG, said that, a parent cannot be expected to know what's going on in the dependency case.
That's our 2010 AG case.
The AG case where it was counsel was required for a non-offending parent.
Are we dealing here with a statutory right to counsel, or with a...
There's a statutory right to counsel. There is a rule that says there's a right to counsel. And there's also possibly, because there's a mention of the termination of parental rights of the mother, there is a possibility that there's a constitutional right to counsel.
But isn't there a statute that requires that the court advise the father that he has a right to have a lawyer present?
Yes, 39013.
Right. Yeah.
Is it a fundamental
The
law?
courts have held that in a dependency of statutory right to counsel, even though the one case that is said that I cited in my brief said it is fundamental.
Counsel, there may be, but is this a constitutional right, or is it a statutory right? And if it's statutory, is there a fundamental aspect to this?
Well, there is a fundamental aspect to it, especially with this case, because they ordered termination of the mother's parental rights immediately. Okay, so that affects the father. Okay, so he's now going to be involved as a party in a termination of parental rights proceeding. Whether or not he has a dependency proceeding filed against him, the court already ordered a termination of parental rights proceeding. Under the Santosky v. Kramer, the father, essentially, as a party to a termination of parental rights case, would have a constitutional right to counsel. And
setting that aside, would the father have a constitutional right to counsel if this were not
the case law says that it's statutory right for counsel in a dependency proceeding.
So if the court errs, is it per se reversible if it's just statutory? I mean, we value the right to counsel.
We value the right to counsel. We value the right to
maybe it's not always
as fundamental as egregious.
Is something else. Yes.
But I will go back to
you're here
AG versus DCF, which said it was a fundamental, and that case is like His Honor said, it's dispositive, and they essentially went to the point where saying that there's essentially a fundamental right to counsel here, and they were only talking about a dependency.
AG is almost identical.
Almost identical.
That's up in the first.
That's up in the first.
Okay, we're 450 miles from there.
Approximately.
But we're still in the state of Florida.
Yeah.
But,
and there's nothing in the third.
There were some who.
There's nothing in the third that counteracts that. And in my petition, I think I do state that AG versus Department of Children and Families, 65 Southern 3rd, 1180, 1183, cited to in re AG out of this circuit to establish that right to counsel. So,
when was the shelter hearing?
Shelter hearing was on the 11th of April.
Of this year?
Of this year, 2012.
So the court was bound by AG from the first district?
Yes, because that was earlier in the year.
Right.
That was in 2011.
But we're not. We're not.
You're not bound by it.
No, we're not.
You're not bound by it. That's correct. But I think you are bound by in re AG out of this district, which says that a parent can't be expected to navigate through a dependency case.
Well, that may be true, but the question is it a fundamental error isn't the question here, is it fundamental error for this gentleman not to have had a lawyer?
Well, Your Honor, I would say...
Is that the question? Is that the issue?
That's one of the issues. The other issue was there was no findings against him in the shelter order. But I would direct your court's attention to Section 39.013, subsection 9, and subsection A. It says, at each stage of the proceedings under this chapter, the court shall advise the parents of the right to counsel.
So is the error, when it occurs, fundamental?
In this case, I would say it is because there is a termination of parental rights case mentioned. If it was just a dependency case as to two different parents, it could be distinguished as not being fundamental.
But it's a shelter order sheltering the child in some place other than with the father.
Right.
It's a fundamental right to counsel as to a fundamental right of the father to the possession of the child.
That's correct, Your Honor. I would say that. However,
let's get down to brass tacks for a second.
Okay.
If we reverse, all that happens is you go back to the trial court for another shelter hearing at which you're present, correct?
Right. That's correct. And then everything's brought out. The court gets to re-examine. It'll be down in the 16th Circuit.
Correct.
In front of Judge Garcia. It's scheduled for hearing on Monday, June 11th.
What's scheduled for hearing?
This case.
Or what?
Depending on whatever we decide?
No. Just a regular status hearing.
But, the finding at the shelter hearing is not going to have any impact on your client throughout the proceeding, is it?
It should, because of the fact that the children have been removed. He's already lost parental rights. The children were removed. There was no harm found that he caused or imminent.
Well, they're not going to bring the child to the hearing, and they're not going to bring the child from her shelter.
They brought NW in the transcript. They brought NW to the hearing. They didn't bring the newborn.
What is the current? At present, the dependency proceeding has not occurred, correct?
The dependency proceeding, and if I may, there's been a dependency petition filed against the father.
Yes. And
there's been a termination of parental rights petition filed against the mother.
And
has
the dependency proceeding against the father had its adjudicatory hearing yet?
No. We're still at the stage of a denial's been filed.
Is that what is scheduled for June 11th?
June 11th is just a status.
A report. Okay.
To find out what's going on because of the transfer and because
and obviously the CPR has not been scheduled.
But will it really make any difference? The child now has, the father now has counseled you.
Yes, Your Honor.
The child is not going to be removed from the shelter until there's some kind of adjudication, is there? Some kind of determination as to the father's right not to have the child sheltered where the child is.
Right, Your Honor.
And at that hearing, you are going to be there and represent the father's rights. So isn't this really moot? Isn't this issue, your presence at the shelter hearing is not, or non-presence is really not going to affect what happens to this child or what happens to the father and his representation as to his fundamental rights. He's going to get that representation. He has that representation.
He has the representation. But if the shelter hearing order is quashed,
yes,
it'll go back to the court for a review. This court can send it back for a review.
Yes, but what is going to happen to the child?
The child's going to stay until the trial court determines, unless this court enters an order quashing the order and releasing the child, which I doubt that you're going to do.
That's exactly right.
Right.
But we're not going to do that.
Right.
So what's the difference?
Well, it goes back for a hearing.
It'll go back for a hearing anyway.
It is possible, at least in theory, that the child or children will be given to the father, or there are two sisters of the father out there, and I suppose that if home studies are done, there would be a possibility there.
That's correct.
Where is the child being sheltered now?
The children are with the sisters. Okay? But what happens is that it is...
So I really do not see that this is you pardon me for expressing this view in this case when the department... This is a case of controversy.
Well, see, Your Honor, the
father's
rights have been
you don't want the child removed from the place of shelter at this time, do you?
Your Honor, if the child could be placed with the father...
I'm not. As a practical matter, isn't the child going to... Or the children, I'm sorry. Isn't going to remain with the aunt until there is a hearing at which you are present?
Well, they're not there, right? They're in the shelter.
No, they're with the sisters.
They're sheltered with the sisters.
Right now. What happens with this...
They're not in a shelter, they're in with the sisters.
This court quashes the order.
Yes.
We could go back and we could have a hearing to determine whether it was a valid sheltering. Evidence could be presented. Mr. G.W. could be represented.
Anyway.
But what would be a different result?
The trial court could deny it, and then I would have to come back here on another question.
What would be a different result if you went back and had another shelter hearing? What are the potential different results?
If you were there,
wait a minute, I'd like to hear an answer to this.
The potential different result is that the father could have maintained custody of one or both of his children.
But it won't happen. It will not happen.
We don't know that. I don't see any allegations in that shelter petition. I don't see any allegations in the...
if you win at the hearing,
any harm.
Then the children will be removed from the aunts, if it's appropriate, and returned to the father. But at that time, he will be represented by counsel. The only real issue here is counsel. It doesn't make any difference, it seems to me.
But I gather that you are not conceding that the father should not get the children in the interim between now and whenever the dependency hearing is. Am I correct?
That's correct, Your Honor. Because it changes everything. If the father has custody of the children, and we do go to it,
whatever the facts are or may be, you're here because you want the opportunity for the father to argue to have the children taken from not taken in a necessarily bad sense, but placed with or given to the father to be held and so on, nurtured until the dependency hearing.
That's correct. He would like custody, the children, and would like representation at the hearing, with them.
But you just said, and very questioningly, that we're not going to do that.
What's that? But no, I think
the order that the children removed to the father because he wasn't represented at the shelter.
But I understand what Judge Shepard is asking, is that through the adjudicatory process, until the adjudicator, I'm talking about during that time frame.
The issue is not whether you're right or wrong on the law. He was I think we can assume, entitled to be appointed counsel, and it's an error to do so. The question is whether it's irremediable error, because it seems to me it's harmless error, because the same thing is going to happen now that you're properly appointed and representing him. It's no difference.
We don't know that, do we? We don't know that.
How can we turn back the clock?
We don't know that the father is not going to be given custody of the child at the shelter hearing.
That's correct.
Is
it possible, I assume that it is, that a dependency petition can be filed and the children are still with the arguably offending parent on the dependency side?
That happens certain times, which they call the direct file, where the Department of Children and Family may allow the children to stay with the parents and they directly file a dependency petition. They still make the allegations of abuse, abandonment, or neglect,
but the children
have never been removed.
The children are not removed.
And they can still proceed forward on the dependency petition. I'd like to reserve 1 minute for rebuttal.
I'll give you a minute.
May it please the Court, Karla Perkins on behalf of the Department. In addressing AG, I would like to point out that case specifically stated the trial court did not ask the father if he had secured representation, nor did the trial court clarify whether the father wished to waive his right to counsel. Here the judge appointed counsel for the father.
But she didn't ask the father if he was waiving his right to have counsel present at the hearing. The transcript doesn't suggest that at all.
No, the transcript tells us that the court, after the court questioned the father as to how much he was making, his name, his social security, how much he was making, the court then appointed Mr. Joyce as counsel for...
The court, in my reading of the transcript, the court never said to the father, would you like to have a lawyer present with you at this hearing? Those words I didn't find anywhere in the transcript. Am I wrong about that?
You're correct. The court doesn't ask that. The court actually appointed counsel, and here's what happens though, because the statute
she didn't appoint counsel until the very end. It came up on the last page, last minute of the transcript.
No, it's not on the last page of the transcript.
I see it. I see counsel appointed for the mother earlier on, and then the father's. I mean, if it occurred, it sure didn't get across to the father, because it says, hold on, I didn't know I had one. So, which is the purpose of the statute, to be sure you have one.
Page 11 of the transcript reflects that the court was appointing counsel, and the court said, I'm appointing counsel. Who comes up next? Richard Joyce comes up next. Judge said, okay, I haven't seen and have you. Nobody saw him there in the courtroom. What happens, though, is the statute actually, if you go to 39-4025C2, it actually says that if the parents are legal custodians for the shelter hearing without legal counsel, then at their request, the shelter hearing may be continued up to 72 hours to enable the parents or legal custodians to consult legal counsel. I'll tell you also, if you go back to go back to AG, actually, because the father's name was AG. It says that following the hearing...
Ours or the first district?
No, the first DCA.
Okay.
This court said all parents have the right to counsel. In re AG deals with the shelter hearing
in the first district.
The first district, correct. And in that one there, it says, following the hearing, the trial court issued a shelter order adopting the allegations in the petition. The father challenged the order in a motion for rehearing. Mr. Joyce had the ability to move for a hearing and say to the court, Judge, my client here wants custody. I mean,
there was no obligation for him to move for rehearing.
He may not have had the obligation, but the court actually, in spite of all of the counsel not being present for the father, because obviously if they're appointing someone from the defense wheel, all defense lawyers are not going to sit in the courtrooms waiting for their names to come up. So regional counsel is there until the first parent gets regional counsel. The attorney from the defense wheel now, and the court told the father, call your lawyer. If he had called them, they could have put it on within a number of days. But I'll tell you,
who is representing the mother in this case?
Regional counsel.
And the father.
And the father gets Mr. Joyce.
Oh, all right.
He's from the defense wheel. But if you go to page 11 of the transcript, right? The court is advised by the department. The father has 2 adult daughters. One's 24, one's 25 years old. Those were the two. And the court was advised there are two daughters here of the father who are seeking custody of the children. There is nowhere in this transcript that this father ever asked for custody of the children. The fact was he also tested. That was the first time he was tested. He tested positive for cocaine and OxyContin. And he told the court he's taking cocaine for medicinal purposes. So the court said, well, you need services. And his response was, he doesn't care what anyone has to say. He's not doing any drug program. So basically...
If he had a lawyer, the answer might have been a little different.
Well, Judge, he had the opportunity. You know, if he called his lawyer that day, the opportunity to move before the court. You know, shelter proceedings are emergency proceedings. There's always
But again, 39.013, the court has a duty to advise parents of the right to counsel, a duty to appoint counsel for indigent parents, ascertain whether the right to counsel is understood, determine whether any waiver of counsel is knowing and intelligent. But the court didn't do any of those things in this case, other than appoint counsel.
But Judge, here's what. The fact that he had counsel means that, and the judge tells him specifically, call your lawyer. That meant that she could that very day, and then call Mr. Joyce.
She didn't say, call your lawyer before we continue with this hearing. She didn't say, you have a right to have a lawyer present with you at this hearing. She didn't ask him whether or not he waived that right and explain it to him. She didn't do any of those things. And listen, I understand, but to say that counsel was appointed for this hearing is illusory. There is no benefit from having a lawyer appointed unless you know that you have a right to have a lawyer present with you at that hearing and that you have a right to continue the hearing for 72 hours so your lawyer can be there. And I suspect Mr. Joyce would have been there at the shelter hearing that occurred with him those 72 hours. And the statute says clearly you don't have to remove these children from shelter during those 72 hours. They can remain protected. So this could all have been done correctly by simply advising him of the right to counsel, letting him tell the court whether he wanted to waive that right or not.
But Judge, what you're saying then is the legislature is incorrect in their language, because the legislature was the one that set up 394025B because of the fact, here's the way it works. The law says if the department removes children, you have to have a hearing within 24 hours. That means that at the time of removal, they find the parents, they tell the parents, this is where the hearing is, this is the time, place, you need to be there.
Yeah, but Ms. Perkins, the legislature also said that you can extend that hearing for 72 more hours to give the parent the right to have counsel present.
But Judge, he had counsel.
It does say that, right?
To do.
I mean, I'm not making that up. Doesn't it say that?
No, it says, I read the statute, it says that the parent can request the continuance. The fact is, the father has the ability to say, Judge.
Is this a fundamental right? Is it a fundamental right?
This is not a fundamental right. This is a probable cause hearing.
Yes, I understand that, but is the right to counsel at that hearing a fundamental right?
Statutory.
It's a due process right, right?
It's a statutory right. The courts have held it's a violation of due process.
What case other than the First District say? Does the First District case say that it's a fundamental right,
no.
A constitutional right?
It doesn't say that.
No.
It says it's a due process violation to fail to have counsel, therefore I'm to advise him of counsel.
The Florida Supreme Court has said that the right to counsel in the state of Florida in dependency cases, it's statutory. It's not constitutional. The fundamental comes from the least restrictive means when we're going into the termination of parental rights posture. That's when they say then you're removing the parent's right to severing it permanently. This is a probable cause. It's like a judge in criminal signing off on an affidavit. I mean, this is hearsay comes into these types of hearings. It's not going to affect the father. He has the ability to defend himself. It does not make his children dependent just because of this probable cause finding. So the department would ask that the court not quash. Thank you.
Mr. Joyce, you have your minute.
Okay. Thank you, Your Honor. I just request that you will quash and send it back to the trial court.
Thank you.
Thank you.